Welcome to this explainer. Today, we're totally demystifying the South African legal system. We'll be exploring the fascinating architecture behind how law is made, how it's applied, and exactly how it's interpreted. So, if you've ever wondered how a modern legal system actually operates from the ground up, you are definitely in the right place. Let's jump in.
Here is our blueprint of justice for today's session. We're starting with the roots of the legal system, then we'll look at where law actually comes from, climb the hierarchy of the courts, explore the power of precedent, and finally, dissect the anatomy of a court judgment.
Section 1. Roots of the legal system. To truly understand the structure of the law today, we really have to look at the historical soil it grew from.
South Africa has this incredibly fascinating, uncodified, mixed legal heritage. It's kind of a wild ride, honestly. We start way back in 753 BC with Roman law. Fast forward to the 15th and 16th centuries, and that Roman law actually fused with Dutch customary law, creating, you guessed it, Roman-Dutch law. This is the exact system brought to the Cape by Jan van Riebeeck in 1652. Then, skipping ahead past 1814, English law began to infiltrate the system, which brought in things like the jury system. Finally, 1910 marks a massive milestone, the Union of South Africa, which brought a uniform system of statute law to the entire country.
Section 2. Where law comes from. Now that we've got that historical foundation mapped out, let's examine the modern materials used to build today's legal system. So, what is the absolute bedrock here? It's the 1996 Constitution. See, previously, the country operated under parliamentary supremacy, meaning Parliament could pass basically any law it wanted. But today, we have constitutional supremacy. It is a complete game changer. Any law or conduct that clashes with the Constitution is completely invalid. It is the ultimate benchmark for justice in the Republic.
Tucked right inside that Constitution is the Bill of Rights, which legally binds all branches of government. It guarantees your first-generation rights. These are things like your fundamental right to equality, dignity, and life, but it also includes second-generation rights, which place a positive obligation on the state to provide essential things like housing and health care. But here's the absolutely crucial thing to remember: none of these rights are absolute. They can actually be limited, but only if that limitation is reasonable, justifiable in an open democracy, and applied by a law of general application.
Okay, beyond the written Constitution, unwritten rules can become law too. We call this customary law. A brilliant example is this famous 1921 case, Van Breda v. Jacobs. Basically, a bunch of local fishermen had a long-standing custom that if you set your lines on a beach to catch a moving shoal of fish, nobody else could set lines right in front of yours. The court validated this local fishing custom as actual, enforceable law because it met 4 incredibly strict steps. It was reasonable, it had existed for a long time, it was generally recognized by the community, and its contents were completely certain and clear. I mean, who knew a dispute over a moving shoal of fish would literally shape national law? Aside from the Constitution and customary law, judges have a few other tools in their judicial toolbox. The biggest is statute law, which is legislation passed by Parliament or municipalities. Case law, which are past court judgments, is also critical. Surprisingly, judges will even look back at the old authorities, literally dusting off ancient Roman and Roman-Dutch jurists. And if they're really stuck, they can look at foreign law for guidance. Just keep in mind, foreign law is only persuasive, it's never strictly binding.
Section 3. Hierarchy of the courts. We know where the law comes from, so let's check out the physical structure of the system itself.
There's a very clear dividing line when it comes to the types of courts you might find yourself in. On one side, we have the superior courts. These are the heavy hitters with wide jurisdiction, and they meticulously keep records of their proceedings. On the flip side are the lower courts. These handle much more specific, localized matters, and they actually aren't required to keep those same extensive records.
Let's quickly trace the exact chain of command in the judiciary, top to bottom. At the absolute peak is the Constitutional Court, the highest court in all matters with its 11 judges. Just below that sits the Supreme Court of Appeal down in Bloemfontein. Then we have the various provincial divisions of the High Court. Below them sit the magistrates' courts that you'll find in most towns. And finally, right at the foundational level, we have the small claims courts.
Now focusing on that small claims court for a second. It's awesome because it's designed to be prompt and affordable for everyday people. You handle minor civil claims up to R15,000, and you literally aren't allowed to bring a lawyer with you. But you absolutely cannot use it for the heavy stuff. Divorces, disputes over a will, malicious prosecution, wrongful imprisonment. For those complex issues, you have no choice but to climb higher up the court hierarchy.
Section 4. The power of precedent.
With the courts fully mapped out, let's talk about the invisible glue holding their decisions together.
The absolute bedrock of case law is this Latin phrase, stare decisis. It literally translates to the decision stands. Basically, this doctrine means judges can't just wake up and invent new rules based on their mood. Instead, they are firmly bound by earlier decisions. It's the mechanism that turns a single judge's ruling into a stable legal rule for the entire country.
What's super interesting is how the South African system strikes a balance here. See, if you rigidly follow the past, no matter what, you might enforce a terribly outdated, unfair rule. But if you ignore the past completely, you get total legal chaos. So, the courts follow a pragmatic middle course. A court is bound by its own prior decisions unless it can be clearly shown that the previous decision was just patently wrong.
So how does this stare decisis actually flow through the hierarchy? Well, it's highly structured. Every single court is completely bound by the court above it. A magistrate must follow the high court in their area. A high court must follow the Supreme Court of Appeal. Interestingly, though, a single high court judge in, say, Johannesburg is not technically bound by a different high court division in Cape Town, although they'll still treat each other's decisions with a lot of respect.
Section 5. Anatomy of a Court Judgment. For our final section, let's zoom all the way in on a single brick in this massive legal structure to see how a judgment actually works on paper.
When you actually sit down to read a judge's ruling, you got to split the text into two distinct buckets. First is the ratio decidiendi, the actual reason for the decision. This is the conclusion based directly on the material facts of the case, and this is the only part that is legally binding on future courts. The second bucket is the obiter dictum, an incidental remark. If the judge goes off on a tangent or gives a hypothetical example, that's obiter dictum. It might be persuasive, but it absolutely does not create binding law.
But, what if a judge is staring down a binding ratio descendendi from an old case that just really shouldn't apply to the current dispute? Well, they use this genius technique called distinguishing. The judge will meticulously prove that the material facts of their current case are fundamentally different from the older case. If the facts are different, the old rule simply doesn't fit, and the judge escapes the binding force of stare decisis entirely.
When you look at a typical page from the South African law reports, before you even get to the judge's actual words, you'll see a headnote in small print right at the top. This is just a helpful summary of the gist of the judgment, written by the editors of the reports. Now, it has zero official legal status, but let me tell you, it is an absolute lifesaver for anyone trying to quickly figure out what a massive case is actually about.
Above that headnote is the citation. Think of a legal citation as a highly specific GPS coordinate for a case. Let's decode one right now. National Sorghum Breweries Limited v. Corp Capital Bank Limited 2006 6 SA 208 SCA. The first name is your applicant. The V is just versus. The second name is the respondent. Then we get the year, 2006, and the part number, 6. SA tells us it's in the South African law reports, found precisely on page 208. Finally, SCA tells us the judgment was delivered by the Supreme Court of Appeal. Once you know this formula, you can literally track down any judgment in the country's history.
Now, you are definitely going to stumble across some Latin while reading these reports. Please don't let it intimidate you. It's basically just judicial shorthand. Simbly just means this appears to be the case. Alter means otherwise, suggesting the outcome would change if the facts were different. Cur ad vivat simply means the court wants to take some time to consider its decision before ruling. And postea literally means afterwards, indicating the date the final judgment was actually delivered to the court.
And that brings us to the end of our structural tour. We've seen how rules from a farming community in ancient Rome fused with Dutch and English traditions to lay the foundation for a modern constitutional democracy. We've seen how courts use stare decisis to build a stable wall of precedent, brick by brick. But it leaves us with a really provocative question. As technology and society evolve at lightning speed, how will this highly structured, historically grounded system handle the completely unprecedented cases of our future? Will the old bricks hold up, or are we going to need entirely new courts? Thanks for joining me for this explainer, and keep exploring the systems that shape our world.